Earlier in the year, we brought you a report about 70 soldiers who were given a presidential pardon after being sentenced to death in 2014 for mutiny. Still, men are awaiting entitlements due to them. So due to this, human rights lawyer Femi Falana is urging the Nigerian army to document 2025 instead of 2014 as discharge day for the 70 soldiers granted pardon by the Council of State in 2022. The senior advocate of Nigeria says the court may be his next destination if the army fails to do what he calls the proper thing. Arise correspondent Ovitemi George reports.
Some of the ex-soldiers meet with human rights lawyer Femi Falana in his Ikeja chambers in Lagos. They are done with documentation and have received parking allowances from the army. The authorities have also issued discharge certificates to them, but the ex-soldiers seem to have an observation.
We are surprised to see in the discharge certificate that we were discharged 2014. Even while we were in detention then, Army were still paying us till 2016. Does it mean Army have discharged us 2014 and still paying us till 2016? The date of discharge is supposed to be till date, not 2014. Based on the discussion they had with our lawyer, that they are not willing to accept us into the service, and we have agreed to go voluntarily. So Army should not give us compulsory discharge, because if they give us compulsory discharge, it then means that they have not considered the instrument of pardon given to us by His Excellency President Muhammad Buhari.
They neglected the presidential pardon, but we were surprised. They didn't even regard the presidential pardon. They now fall on their own decision to have compulsorily discharged us.
The instrument of the pardon that is being given to us, we don't know.
Senior advocate of Nigeria, Femi Falana, who took the case pro bono, believes something can still be done about the documented date of discharge on the certificates.
We're convinced that they ought to have been discharged and acquitted absolutely by the military tribunal or the chief of army staff at the material time. But since they only committed their sentences to 10 years, we decided to appeal to the president having regards to all the facts and circumstances of their conviction. And the president decided to pardon them. And what that means is that in law, it's as if the offense was never committed. All the consequences were obliterated. And so, strictly speaking, they're entitled to go back to the military. And so, if you're not going to have them brought back, the authorities cannot backdate their discharge from the military. Because you're just discharging them now. So you cannot backdate it to 2014. We're going to contact the military authorities, and we're very confident that the proper thing will be done at the end of the day. And if it is not done, we have to go to court.
The date of discharge on the certificates is now a subject for debate and perhaps interpretation of the meaning of pardon as granted by the Council of State. Ovitemi George, Arise News.
So joining us now on the show to discuss the case of the soldiers and yet to get their benefit is Femi Falana, senior advocate of Nigeria. Welcome to the show, sir. I'd like to ask you, sir, just take us through what really transpired with these soldiers and why are we still holding their benefits and what can be done to get them justice, sir.
Well, thank you very much. And I must commend your station for the interest that has been shown in the case of the 70 soldiers that were convicted and sentenced to death in 2015. What happened was that based on the injustice that characterized their trial, conviction, and sentence, we petitioned the authorities. And because of the seriousness, the gravity of the issues that we raised, the Chief of Army Staff, while exercising his powers under the Nigerian Armed Forces Act, commuted the death sentence to 10 years imprisonment. The soldiers spent the 10 years imprisonment. Of course, we filed an appeal. We got 4 of them. The Court of Appeal discharged and acquitted 4 of them. The others lost their appeal technically. So we're going to the Supreme Court. When we had to appeal to the president, then President Muhammadu Buhari and the Commander-in-Chief of the Armed Forces, to consider the case of these soldiers, as well as a general, General Enito Ransom Kuti, who were convicted, without any basis. Because you can't blame them for, they were willing to fight, but they were not given adequate weapons to confront the well-armed terrorists. And it was like, it's making some sacrificial lambs of these young people. The president considered the representation made by us and decided, pursuant to Section 175 of the Constitution, to pardon them. And what that means, and we wrote to the military authorities, the implication of the pardon is that the offense has been forgiven, the consequences completely obliterated. In fact, if they hadn't gone to jail, they would not have been imprisoned based on the pardon. But having gone to jail, we are now asking you to restore them, which is the essence of the pardon. Because pardon means they have been, in the words of the Court of Appeal, in the case of Fala and Obasanjo, each of them has become novus homo, a new man, a new person. So you have to take them back. Oh, they pleaded with the soldiers. Since you have been away for almost 10 years, it's going to be difficult to have you fully rehabilitated. So please consider, opting out of the military. It took time to convince the young people, the soldiers. And so they then agreed to disengage voluntarily. But our utter chagrin, in distributing the discharge certificates to the soldiers, the military authorities said they were being discharged compulsorily. 2, the military authorities also varied the pardon granted by the president by saying, we are going to calculate your entitlements as of 2014. Meanwhile, the pardon was granted in 2022. Meanwhile, they have spent 10 years in prison. And so, some of them received their salaries up to 2016. So we are now asking the military authorities, on what basis can you discharge those who have left the military voluntarily? How can you say they have been compulsorily discharged? Secondly, why are you not going to calculate their entitlements up to 2022 when they were pardoned by the president? And this is the way it is done in law. And in this particular instance, the 4 of them that won their case in the Court of Appeal, who were also pardoned by the president, are going to have their entitlements calculated up to 2022. General Ransom Kuti, who was illegally downgraded, he was demoted from from brigadier general to the rank of a colonel. Of course, in line with the pardon, his rank was restored, but because of age, he could no longer go back to the military, but he was given all his entitlements up to the time of the pardon. So we are asking that what is good for the goose should be good for the gander by also treating all the 70 soldiers in like manner. So this is where we are. And I'm in touch with the military authorities, I'm in touch with the legal department, and I'm sure this matter will be well considered. Okay. So as to avoid unending litigation on the matter.
Absolutely. I understand there are also issues around pensions involved here, because if they're considered up until that the 2022, the year of the pardon, then many of them would qualify for their pensions. And then the second issue on the ground is the issue of rank. So you've given an example of somebody whose rank was restored, but some of the soldiers are saying that by now they would have been promoted and they would have moved on to the next rank. But that's not a given. How do you treat these issues, specifically the pension and that of rank promotion? It seems that like a bit of a far stretch given the context of the case.
Well, if the authorities are saying, we are not ready to take you back for its implications, and the young people, the soldiers have exhibited maturity and understanding by saying, okay, we'll leave the military voluntarily. The government, the military authorities must reciprocate in like manner by saying, all right, as of 2022, we are going to retire you. Between 2014, when you were convicted and sentenced and jailed, what between then and 2022 when you are pardoned, what rank will you have attained? And then the rank must be given to them. And if this is not going to be done, I mean, the courts are there to really intervene in this matter. And there are a legion of cases, locally and internationally, where the rights of people are pardoned have been granted. I mean, for instance, in the case of Falana and Obasanjo that I mentioned, Chief Falana said General Obasanjo was not qualified to have contested the election because he was convicted during the military, treason. He was charged for treason and convicted under the Abacha military junta. But the court said, since General Abdulsalami Abubakar, as the military head of state, has granted pardon to him, he has become a novus homo, a new man. Therefore, he cannot be disqualified on the ground of conviction because he has been pardoned. The same treatment must be meted out to these young people. That's our demand. Simple and straightforward.
Agreed. Well, thank you and good morning. Thank you for joining us. I wonder if you could give us a bit of insight into their day-to-day realities while they're awaiting their benefits. How are all of these people, 70 of them, across the span of seniority and age groups, how are they surviving? What is their day-to-day reality like?
It's been very tough, very, very tough for them. Very, very tough. And the system doesn't take care of the poor. I mean, for instance, when 70 of them were released from custody, from prison custody, the system simply turned them to the street. And these are young people who have been trained how to handle weapons. And so we had to raise money. Our law firm had to raise money to ensure that each of them was able to travel home. And we, pleaded with them. Find something lawful to do. Don't engage in any crime so that you won't give the authorities the opportunity to say, oh, we told you. They are not good people. And all of them have been law-abiding, and they have tried to look for menial jobs here and there. For instance, we have to engage the services of two of them, to keep watch over our office. And we've also made recommendations in many instances to get them employed, by many establishments.
Sorry to interrupt
the
you,
system
sir.
doesn't bother about them.
Does that mean that none of them are gainfully employed now, apart from the two that you said are working for you? Are none of them gainfully employed now, all of these years later?
It was even difficult to engage them because they didn't give them their discharge certificate until last month. A couple of months ago. So, and they can now take the certificate to some security agencies when the military will have retired. But when you also say compulsorily retire, you give the impression that maybe, they committed some offense or some offenses, hence we are flushing them out. But the president has pardoned them. So, and they decided to disengage voluntarily. So the discharge certificate will have to be amended in order to enhance their opportunities to be gainfully employed.
Okay.
But right now, they are not employed.
Okay, sir. So, is this not an aberration that the commander-in-chief issued a pardon and the institution where the commander-in-chief is commander of cannot fully align with the pardon? Is that not a reflection of the lawlessness of Nigerian states? And I've been trying to pick your brain about many issues in our society, because there's no way the great Femi Falana will come and I'll just allow him, talk about one issue and go like that. I will be Oliver Twist and I will sneak it in. So I want to also sneak in the aberration that happened with the state of emergency in Rivers State, the aberration that is going on with the budgeting system in the state of emergency in Rivers State, that we are now seeing revelations that about 24 billion is used for CCTV cameras and all sorts happening. And also people are talking about the local government laws in Lagos State and the overreach. Does all of this not tie around the conversations about the lack of this respect for the rule of law in our country?
Well, for me, I see them as challenges because we operate in an atmosphere of grand impunity. The rule of law is hardly observed by governments in our country. It is as if we're still under a military dictatorship in many instances. For instance, we're talking of the pardon granted by the president. What is the meaning? It is that the consequences of the offense are obliterated, cancelled completely. So you can't say, whereas we convicted you, we cannot take you back, you cannot restore you, you cannot vary or modify the instrument of pardon granted by the president or the governor of a state under the Constitution. 2, nobody, no lawyer, including those who are supporting emergency rule, has pointed to any section of the Constitution that allows the president to impose a state of emergency to the extent of removing or suspending elected officials. What the president is asked to do under Section 305 of the Constitution is to impose a state of emergency, to adopt extraordinary measures to restore law and order. Nowhere is it stated that the president can suspend the governor, even for one day. But for me, our courts must stand up this time around. It's not about President Tinubu or Governor Fubara. We must know where we stand. We cannot operate a democratic system of government where the courts will not make pronouncements on very serious infractions of the Constitution. Otherwise, we're going to be in crisis. Take for instance, in the United States of America, President Donald Trump will have turned that country into a complete third world nation. But for the courts, but for the intervention of the courts. And these cases will not have to last for 3 months, 6 months, because what is going on in Nigeria is that all the cases in court on the emergency rule will not be decided until the restoration of the governor. And by the time the democratic structures are now put back in place, you then be told by our court, oh, these cases have become academic. The court does not engage in academic exercises. And therefore, again, we wait for the next one. In 2002, 2004, it happened. In 2006, it happened in Ekiti. Plateau in 2004. Now, it's reverse. Once the court does not define the extent of the powers of the president, when an emergency rule or a state of emergency is imposed on a state or on the entire country or on a local government, we are going to be in crisis. With respect to Lagos State, the new electoral law in Lagos State, local government administration law, is to the effect that those who have completed the term of a vice chairman who have completed the terms of chairman cannot contest more than once, because otherwise they would then spend like 10 or 12 years, whereas the law provides for a maximum period of 8 years. So this is the new law that has just been enacted in Lagos, and the whole idea is to reconcile the law with the constitution of the country. And I think it's a good development.
Okay. Thank you so much. I really appreciate you, Femi.
Thank you so much for joining us this morning. We will take that. It's Femi Falana, of course, Senior Advocate of Nigeria. Always a pleasure. Thank you for joining us. We'll take